Hi, y'all, and welcome to the live stream. The Titanic sank in 1912, but it's apparently not yet done claiming victims. OceanGate, a privately held company, provides submersibles for commercial research and military uses, and it also provided them for paid trips to the ocean floor to see the Titanic wreckage where it had sunk way back in 1912. On June 18th, the company suddenly lost contact with the submersible that was headed down to view and to take tourists to see the Titanic wreckage. 4 passengers and a pilot were missing. For most of this week, the world was mesmerized, hoping that the 5 people could be found and freed. At one point, there was even a report that people looking for the submersible, for the sub, had heard a banging noise, which might be the passengers hitting on the hull of the ship to attract attention. So hopes were raised at that point. But there was no food or water aboard, at least none to sustain the group, and only 96 hours of air. So time was very short. Well, those hopes did not materialize. And yesterday we learned that a debris field was found, and the Coast Guard says that the vessel is in pieces on the ocean floor near the Titanic. All 5 people who were on the sub definitely were lost. First, there was Stockton Rush. He was the CEO of OceanGate. Shahzada Dawood, a Pakistani businessman and father, and his son, Suleiman Dawood, who was just 19 years old and had gone on this trip with his father. His aunt said he was really frightened by it, but went to please his father. Then Hamish Harding, a British billionaire who owned Action Aviation, and Paul-Henri Nargeolet, a French dive expert who had been to the Titanic more than 30 times, but was going to see the actual wreckage. Now, this was an absolutely catastrophic result, but there will also be legal fallout, and that's what I wanted to talk about today. I want to divide this into 3 sections. First, I want to talk about what the Titan, the submersible, was supposed to do. And then I want to talk about what OceanGate knew about whether the Titan had problems, whether it would have problems surviving. And then thirdly, I want to talk about the potential legal consequences for OceanGate, the company that owned the Titan. Now, first of all, and speaking of consequences, there are only good consequences if you like the video and subscribe to the channel. We'd love to have you on board, so please do subscribe. Now, here's what the Titan was supposed to do. It was supposed to take tourists down to the ocean floor so that they could see the Titanic wreck. Not just any tourists, though. They had to be able to fork out $250,000 per person for the privilege of going down to the Titanic. It is 12,500 feet below sea level, and only 5 submersibles in the world can reach that level. The sea level, if you are at sea level, there's 1 bar of pressure, but that far below the surface of the ocean, there are 400 bars of pressure where the Titanic sits. So the company was founded by aerospace engineer and pilot Stockton Rush. And the company was in Everett, Washington. He was very confident, said that the submersible was pretty much invulnerable. And in fact, he was on it, of course, when it imploded. In 2019, he told the Smithsonian magazine that there hadn't been an injury in the commercial sub industry in over 35 years. And he said, in fact, it's obscenely safe because they have all these regulations, but it also hasn't innovated or grown because they have all these regulations. I do have to ask this question. What is obscene about safety? Obscenely safe seems like a contradiction in terms to me. But we also need to talk about the second area, which is what the company knew and what we currently know about what the company knew about the safety of the Titan. From the get-go, the Titan was built differently from other subs. Instead of being, as most deep sea submersibles are, a metal sphere, it had a hull that was carbon fiber cylinder. And used off-the-shelf parts. In fact, bragged about that because part of the point was to make it simple to replace parts so that it could be reused and used regularly for things like tourism. And there was even talk about it used a modified gaming controller as its navigation. In 2015, customers began signing up for the privilege of going down to the Titanic. Some of the first people to sign up were Mark and Sharon Hagel. They signed a contract and put down $10,000 deposits each. They're going to figure in, because they are currently suing the company. They were suing before the Titan was lost. They were already suing. So in 2018, they then wired another $190,258, which I guess was the early bird pricing, to get their places on the Titanic. On the Titan, going down to see the Titanic. But in general, the company continued to work on creating the submersible so that it could go and take people down to the Titanic. But by 2018, the company had a very tough year. In that year, an employee named David Lockridge prepared a report, a document that said the Titan needed more testing. What he said was that there were potential dangers to passengers of the Titan as the submersible reached extreme depths. He was already, in other words, concerned about what actually apparently did happen. And I will say, of course, there's been no actual information about what happened. There have simply been the debris that was found at the bottom of the ocean by the Coast Guard. The Lockridge also said he had concerns about the way that the Titan was designed and about the protocol that OceanGate was using in order to test the reliability of the hull. Lockridge delivered his report, and that prompted a meeting, a lot of discussion, and then Lockridge says he was fired. Instead of fixing the problem, they fired him as the whistleblower. OceanGate says he wasn't an engineer, and he refused to accept what the engineers who knew what they were doing were telling him. OceanGate said it thought Lockridge was trying to be fired, and also said he took confidential information. Lockridge raised the issues with OSHA, the Occupational Safety and Health Administration, raised these issues to the government regulators, and that's when he says OceanGate management fired him and sued him then, of course, for his breach of contract, as I mentioned. Now, Lockridge countersued, and he said in court pleadings that he believed the submersible could subject passengers to potential extreme danger in an experimental submersible. The craft had a viewport. I mean, of course it had to, right? Its whole point was to let passengers see out so that they could see the wreck that they were going to see. That was the whole point of it. But Lockridge said, look, it's built to a certified pressure of 1,300 meters, but it's going to go to 4,000 meters. That's OceanGate, he said, refused to pay for the manufacturer to build a viewport that would meet the required depth of 4,000 meters. His complaints, though, the company fought back against those complaints. Lockridge's lawyer said in a court document, which again, remember, is a public matter, that the paying passengers would not be aware and would not be informed of this experimental design. Also, in that same year, 2018, a professional trade group, Marine Technology Society, the 36 industry experts, deep sea explorers, oceanographers who were members of the vehicles committee of that group wrote to OceanGate. They wrote the CEO, Stockton Rush, and they said that they had, quote, unanimous concern about the safety of the submersible being built. They said they believed that OceanGate needed to have the Titan inspected and certified by an agency like the American Bureau of Shipping, something that would inspect it, an agency that would certify it. Lockridge says he agreed. He says he told the company they should do that, but that OceanGate was unwilling to pay for that. OceanGate marketing had told the public that the Titan would meet or exceed DNV GL certification. That's certification from a Norwegian foundation, Det Norsk Veritas. And the group letter said that at best, that marketing was misleading because OceanGate did not plan to have the gate formally certified. That it, quote, does not appear that OceanGate has the intention of following DNV GL class rules, close quote. They also said that the representations would be misleading, quote, misleading to the public and breaches an industry-wide professional code of conduct we all endeavor to uphold. They warned that the experimental design could lead to potentially catastrophic outcomes. They urged the company to at least test the prototypes under the watch of the DNV or some other certification company. Now, Rush, the CEO, supposedly told the head of that committee that he thought these industry standards were stifling innovation. In a 2019 blog post, the company wrote that its submersible was so innovative that it would take years to get it certified because the agencies would have to be brought up to speed on all the innovations that OceanGate was including, and they wouldn't already know about them because it was, as he put it, so innovative. Now, this was the third year that the company was traveling to the Titanic. In 2021, the first year, the submersible had battery problems. We know that because they said so in the lawsuit that I mentioned was filed by Mark and Sharon Hagel from Florida, some of the early people who tried to buy tickets to go on the Titan. At that point, when the submersible had battery problems, the company said it had to be manually attached to the lifting platform. They said that in a court filing, said there had been modest exterior damage to the submersible, and they canceled the mission. In 2022, though, 28 people successfully used the Titan. In February of 2023, the CEO of OceanGate, Stockton Rush, was sued by Mark and Sharon Hagel of Florida over the refusal to give them back their money from that early purchase of the ticket. They asked for a refund, saying that their trip had been repeatedly canceled. For example, one time because there wasn't enough time to certify that the Titan could reach the depths it needed to go to, and another time because of equipment failure. The in-court pleadings, apparently, the OceanGate actually invited the federal judge to go with them on one of the trips, and she didn't say no, which would have been my immediate response, but apparently she was much braver than I am. So let's talk about the third area of this video, which is the legal fallout. What's going to happen as a result? Well, first, it's likely to start pretty quickly and come from a lot of directions. I just thought through what are some of the things I can see potentially would come as a result of what's happened. One would be an agency investigation or multiple agency investigations. Those might result in financial fines to the company or to other sanctions that would be permitted by whatever enabling statute there is for that agency. Those investigations could take years and would involve experts looking at what had happened and unpacking all of the different things that occurred and trying to fix them. The second area, probably the most obvious, is possible suits from the passengers' families. And we'll talk about the waiver issue in just a minute when I talk about the company's response to some of these issues. So the suits from the passengers' families would probably relate to negligence and gross negligence, the company hiding some of its concerns about the submersible, the company knowing about issues with the submersible. Those would be likely things that would be claimed by the families. The third thing I could think of were other suits related to the recovery efforts, which of course was expensive and involved government costs as well as costs to individuals. So those recovery costs might be included in a suit against the company. The fourth fallout might be related to suits among investors in the company. Who knew what? Who owes what to whom? Who has invested in the company? Do the officers owe to investors who were not officers and did not know? There will be questions like that We can't really know that without knowing the corporate structure. It was a privately held company. The fifth area I can see where there may be lawsuits is people who had purchased tickets, like the Florida couple, had purchased tickets in advance and want their money back, particularly if, as my guess would be, there aren't future trips going to all of the different places that this company went. And that would be the sixth area I can think of, because this was not just a trip to the Titanic. The company also went and took submersibles to other places like the Azores and the Bahamas. They even dangled the possibility of private tours to places that you might be interested in seeing. Now, my guess, it would be unlikely that those would go forward. And so there are, however, going to be people depending on those. There are going to be employees. There are going to be companies that built the submersibles and are expecting to be paid. There are going to be companies that had various contracts to service or to supply the submersibles. There are going to be people who rented dock space. All of those things are going to be possible suits because those different people have been impacted. If the company cancels its future tours, that's going to impact a lot of different people. There are also going to be creditors of the company. Could be any of those people I just named. Could be people who rented dock space, people who provided services to the company. It also could be banks who provided loans to the company in order to build the submersibles. And remember that this company did not just do tourism submersibles. It also had other possible applications, commercial or military. And so there may be contracts there too that will be affected by the fact that the company is going to be in so much legal hot water right now. There are likely to be a lot of lawsuits that get filed from all of these different angles. The last thing I was thinking is that I would not be at all surprised to see new regulations in the field. Submersibles don't have to register with a company, with a country. They don't have to fly a flag. And so, for example, America has a Passenger Vessel Safety Act, and it does regulate submersibles, but the Titan didn't fly an American flag. It didn't operate in American waters, so it was not required to comply with that. Now, if you think, what is the company likely to say? That's the set of possible lawsuits that I can see. And that's just me thinking. There may well be other people and other types of lawsuits. But the company is going to have some responses. And so thinking through, okay, what are the kinds of responses the company is going to have? Well, for example, it's very likely to say that its vessels were tested, that they were safe. Because after all, we don't really know what happened. We don't know why exactly the vessel imploded. We know that that's what we've been told by the Coast Guard, but we don't know the details, and we certainly don't know why it happened. And there's a decent chance we never will, because the submersible is now on the ocean floor. It's going to be difficult to track all of that. The company also may say that when they were warned by the industry, when they were warned by their employee, that they took that advice, that they made changes, that they made and adapted the submersible to make it safe, to comply. So they may say there was nothing wrong with it because we did all those things that you told us to do. Now, let's talk about the waiver issue, because probably the passengers and the pilot were signed waivers. We know that a New York Times former technology columnist, David Pogue, went on one of the expeditions, and he said that in the paperwork, there was a statement that it was an experimental vessel that he would be on, and that it was not approved or certified by any regulatory body and could result in physical injury, emotional trauma, or death. So the company will say, look, we warned you. We told you about this. The company also will probably say that many of the lawsuits were public, that people could have read the documents, could have known that there were questions in some people's minds about the safety, and they could have governed their actions accordingly. So the legal consequences, now when it comes to OSHA, when it comes to other agencies, the waiver probably will not have any impact. But when it comes to the people who were on the sub, the question will be, will those waivers have an impact? And the answer is, and we don't have a copy, so I can't even say exactly what the waiver would have said. I can just presume that there would have been one, especially based on what David Pogue said. But the chances are that the people who were involved, the family members of the people who were killed, are going to argue that the waiver should not protect against gross negligence. It shouldn't protect against information that the company knew and withheld from the people who were going to be going on the trip to the Titanic. Now, will that work? Frankly, it's going to depend. And one of the things it will depend on is where all of these lawsuits get filed, as well as what the waiver itself actually said. The fourth response of the company, I think, is the practical one that is really going to, in the end, probably govern what happens. And practically, I think what the company is going to say is there is not going to be enough money to go around to cover all of the creditors, all of the people who were on the submersible. Everybody can't possibly be covered. Now, Stockton Rush, the CEO, the visionary of the company, died in the accident. And it's hard to picture a future line of customers who are eager to go on a more submersible trip. So it's hard to picture a line of people waiting for contracts with the company, certainly for the tourism side. And it may even make an impact, probably will make an impact for the company in its other lines of business, be they commercial or other types of business. There may also be fallout for the company there as people question, have they been safe enough? Have they followed the rules? Have they been careful? So for all of those reasons, it's going to be likely that the company will have a massive drop in revenue and that it will be difficult for it to cover all of the damages. In practical terms, it may well file for bankruptcy or some other form of monetary protection. And if it does that, then it probably would do that fairly quickly so that all of these various cases could be pulled into underneath the bankruptcy rubric and stayed at least for a while. I mean, when you think about it, it's a very complicated matter. If you just look at the people who were on the submersible, they came from all over. They came from multiple different countries. So finding one court to handle that all is going to be complicated. And all of them will have different rules. They all will have different views of the waiver that was signed by the passengers. So it's going to be complicated. The company would prefer, to the extent possible, to consolidate, to move things into bankruptcy, and to then tell the other courts, whether it wins or not, that everything should be stayed. Can a bankruptcy court in the US tell the French court that the case should be stayed? No, I would not think so. But that's what I would think the company would move toward. They haven't filed bankruptcy. I'm speculating. I'm just telling you what I can kind of envision seeing, because I can imagine that there would be a very difficult time for the company financially. But I'm making that up. I have no inside information about whether they'll file for bankruptcy. They're privately held anyway, so I guess there would be no stock run based on the Harvard lawyerly speculation. So that is what I think is the likely fallout and the likely consequences legally for the company. And we'll be back next week on the channel, Monday, Wednesday, and Friday. We try to go live at 7 p.m. And I'm working on a really special show that I know that you'll like a lot, hoping to interview a DNA expert about the new data and the DNA information that's been found about Bryan Kohberger. We have more details that came out in the state's motion for protective order. And I want to talk to an expert about what this information means. What does it mean? And why? How is it used to finger Bryan Kohberger? What are the privacy ramifications of that? What does it mean for the rest of us as well? So I'm hoping to do that next week. Keep your fingers crossed. And I want to say thank you to all my subscribers who wrote and gave me suggestions of people I could contact or try to talk to about that, because I think we're all kind of curious and would like to know more. So I'm hoping to be able to ask somebody. We're also, of course, covering the Curry Richens case. She's the Utah mom accused of murdering her husband and then writing a children's book about helping her kids get through their grief. She's charged with murder of her husband. That case is pending. She's in jail, but has not been tried yet and has not been found guilty, as Bryan Kohberger also has not been found guilty. So we've been talking about the recent hearing, and we will get back to that next week. So thanks for watching, and I will see you in the next video.